Another great thing about trucking cases is we have great sets of rules. So one problem we have in negligence cases in general is, what is the standard of care? It's what a person of ordinary prudence or reasonably safe person, depending on what state you are, with the exact language, but what a non-negligent person would do or would not do. That is really amorphous. And jurors, they want to be fair, and they want to have some kind of rule so that they know that they're holding people responsible fairly, that it's not just something that after the fact you made up something that no one could have thought of before. Well, in trucking, you have a set of regulations, the Federal Motor Carrier Safety Regulations, and in interstate commerce, every trucking company, every truck driver, everyone that works for a trucking company has to follow these rules. It's required, and they actually promise to do it. But not only that, in intrastate cases, even when you don't have interstate commerce, Texas and every other state has adopted most, if not all, of those regulations. Texas has adopted about 90%. A lot of states have adopted 100%. So, you just double check and make sure that regulation applies to intrastate. But in most cases, we have a set of rules. And then we're going to get into not only the rules, but all sorts of other written standards, handbooks, driver's license manuals, all kinds of things that set out what the rules are. So you don't have this amorphous, what should be done? Well, A, B, and C have to be done, and you promise to do it. So that makes these better cases easier to try, easier for jurors to understand. And then the trucking companies are required to document that they followed the rules. So when a truck driver applies, it has to be a written application. They have to document that they checked the driving record. They have to document that they checked with former employers, to see what the driving safety performance was. They have to keep the driving logs for 6 months. They have to keep the other documents that would show whether or not the driver is faking the logs or not. And so we have all this great document trail that when we know what we're looking for, we can get the documents and prove that they broke the rules, or prove that they didn't keep the documents they're required by law to keep. Now, a lot of times we have to act fast because they're only required by law to keep the documents for 3 months or 6 months or a year, depending on what document it is. But the fact is they're there, and that gives us a huge advantage in these cases as opposed to you're suing a regular driver where you don't have any of this kind of stuff. Because the drivers are out all over the country and the trucking company dispatch is located, in an office somewhere, there has to be a way for the trucking company and the drivers to communicate. Now, a lot of the bigger companies, they use a system called Qualcomm, and it's kind of it's almost like a text messaging service, but it's built into the truck, and it keeps a record of this. So you have a record of the communications going back and forth. And sometimes you find some really good stuff. Like the truck driver's logs will say, I'm off work from this time to this time. And the messages will say, I just arrived here. I'm waiting to get loaded. I'm talking to the person. I'm getting loaded. It shows that they're working. Other companies that are smaller use text messages, but the same thing. If you can get those texts, then you have a good record of the communications of what's going on. So this is something we have in trucking cases we don't have in other cases, and it's something you have to try to get in all your cases. What I really like about a trucking case, though, and it's a way that it appeals to conservative jurors, to the red state Trump voter juror who might otherwise not be a good juror for a trucking case. This is why you get these big verdicts in big red rural counties, and sometimes in some place like Austin that's considered more liberal, you don't get as much money. Because the trucking company makes a promise in writing, under oath, and we make a deal between us as a society and the trucking company. We're telling this trucking company, you want to run an 80,000-pound, hard-to-control, full of blind spots vehicle on the same road as my wife and my children and my parents so you can make money? Well, that's fine. You can do that. But in exchange, you're going to promise to protect us by following a set of safety rules. You're going to make that promise under penalty of perjury, okay? Isn't it fair then, trucking company, if you break that promise, if you break your oath, then you're responsible for the harm that you caused? People get that. It's very simple. So let's talk about how they make the promise. This is a form that was used until recently. Now it's an online form, but it's called an OP1 form. This is application for motor carrier authority. So you and I can't just go buy a truck and start charging people to haul freight down the road. We have to get licensed as a motor carrier. And this is the application that the trucking company has to fill out to get licensed as a motor carrier. And it has a safety certification. So the company has to certify that it has in place a system and an individual responsible for ensuring overall compliance with the federal motor carrier safety regulations. That is, not just that we hand the book to each driver, not just that the driver, he has a CDL, but he must know the rules. No, we have a system and we have somebody in charge, and we're gonna make sure that the drivers at our companies follow these rules, because these are dangerous vehicles on public roads. Of course, if they have a copy of it, that they have in place a driver safety training orientation program. They promise. 90% of the companies, especially the smaller companies, don't do this. They sign this under penalty of perjury, they get their license, and the first thing they do when they hire their first driver is they break their promise because they don't have a safety training and orientation program. But they promise to do it. So when you're doing your failure to train case, and they're saying, well, we don't have an obligation to train, it's like, you promise to do it under oath.